Mr. President, I want to thank each and every one of the members of the Senate this evening for what has been an uncharacteristically civil and productive debate. It has been a civil and productive debate. Now, when I say each and every member of the Senate, what I always mean is the independent bench excluded. Because the independent bench is by definition civil. It is my colleagues opposite who sometimes engage in armed, well, sometimes not armed, but they engage in combat. There was no combat this afternoon, but there was a lot of, unfortunately, there was a lot of misinformation, and it falls to me to deal with that, to deal with that now. Now, if I may be permitted, Mr. President, to seek to treat with the contributions in the order in which they were made. I tried to take notes as I was going along. Sometimes that was not entirely successful, especially in the case of my friend, Senator Arawi, who sometimes speaks at a rate and at a pitch which, you know, is difficult for me to follow. But I'll do my best. So, in the case of Senator Dan Paul, well, first of all, he started off by reminding the House of his vast experience in this field, unparalleled experience in this field. Those are my words. Those are my words. I prefer to be a bit more understated, but Senator Atz in the back is an economist of very high repute. Senator Arawi has carried a torch in respect, whatever you might think of him. Senator Arawi has carried a torch in respect of this matter that few of us who have sat in this chair have managed to carry. Now, Mr. President, I have had 20 years experience in it. I'm not saying anything about that, but I have actually taught at Cambridge, and I've taught at the school that Senator Arawi sends his people to learn FATF and AML compliance issues. I haven't seen Senator Dan Paul there as if, but I haven't seen Senator Arawi there. I mean, I'm pulling your leg. But so that I take the point that I'm not sure if it was you or Senator Dan Paul who lamented the fact that we have had a recent loss from the Office of the Attorney General, and that person is someone who frequents the Cambridge Symposium, but she has perhaps gone on to other pastures, and I wish her well. Now, in respect of the substance of what Senator Dan Paul said, he said, I think, I said, Senator Dan Paul made the point that when we are assessed, it will be on basically what we have done, and that the assessment is going to be rigid, to use my words, and that is true, but we have done quite a bit, and I don't mean only in respect of the passage of legislation, which is what I think the point you were making is that the assessors look not only at what you have on the books, but on how you are implementing the law. So we have made significant progress legislatively, but we have also made significant progress in terms of administration, and we have had an important prosecution in the legislation, with the recent legislation which was passed in 2022, the Civil Asset Recovery. The Civil Asset Law. There's been a decision in the High Court, a reversal in the Court of Appeal, and the matter is awaiting determination in the Privy Council. Now, the decision, the case has thrown up some difficulties with the law, and those difficulties have been addressed here. I'm not sure that you have, that you have spoken to those difficulties. Maybe you have not seen them, but the difficulties have been addressed here. Now, you did speak about targeted sanctions, beneficial ownership, mutual legal assistance, work in progress. You made a point which I didn't quite grasp on the UNSCR, United Nations Security Council resolutions. Now, yes, there is a requirement that the state party must take action without delay. But, I mean, there are nuances to that. And in the case of a person who is in Afghanistan, and this is factual. In the case of someone who is in Afghanistan, if we are asked to act, we act quickly, right away, within hours. But our system is such that there is a distrust of office holders. In some countries, the Attorney General will simply write, and that will be the end of it. We have to go to court. And that is not something that can be done in a matter of hours all the time. In the vast majority of time, that is done within the space of a day. That is how the anti-terrorism unit operates in the Ministry of the Attorney General. So if you get a notification from UNSCR, the application is made to the court and action is taken within the course of a day, which is within hours. But if we live in a society in which you don't trust office holders, and I make no, perhaps that is justifiably so, then you have to understand that the checks and balances that we put in must be respected. And those checks and balances in this case require us to approach the court. The Attorney General cannot write whatever. Now, and I'm not sure that you understand that there are different designations. So so that in the case of the one which is, I think, being spoken of these days, TDA, Tren de Aragua, that's not a UNSCR matter. So the designation, we make the application to court as soon as we can. That does not mean without delay. Doesn't mean that we do it the same day. If we have 2 or 3 to do, that will be done. It just will not be done in one day. And there are other institutions which fall within that category. So it's a little more than simply saying that, oh, the world is going to come to an end because we cannot act without delay. We do act without delay in the vast majority of cases. I would say 90% of the cases where the UN tells us to act. Now, you spoke about the fact that the MER, the assessment will be unforgiving, and that, well, again, the form is not what is important, it is the function. I think I've dealt with that. So it is not simply the legislation, it is how we act. And I think that we have not a perfect system in place, but we do have a developed system in place which complies, which meets muster with our international partners. Now, you did speak of the human, technical, and other resources which are required to push the law along and to make us effective. And the NAMLAC, in my view, is functioning well. There is room for improvement. Senator Lewis made an important point which I intend to, and I give my word to the Senate this evening, that I will be in touch with the Minister of Finance, who should be here any minute now, to establish a body to see exactly how the laws which we have to implement, notwithstanding the comment and the commentary made by my former student, Janelle John Bates, but there is a need for us to look at precisely how the law is being implemented and the effect of the law on ordinary persons and ordinary institutions. I accept that point. It is a very valuable point, and it is something that I intend to take up with the minister. Now, in terms of Senator Atts, I think that, as I've said before, your contribution was a joy again to listen to this afternoon. You spoke of, you were clear-eyed in terms of what we needed to do, and essentially, I think your support, born of experience, I would hate to age any of us, but your support, born of experience, is welcome. This is something that is required of us, and something which we absolutely need to do. Senator Gibbons, on your point, your concerns about confidentiality and journalism, that is spot on again. And all that I can see is that as a lawyer, I have seen, and I'm sure that Senator Arawi and Senator John Bates, Senator Big will agree with me, that we have seen hundreds of years of precedent and practice eroded by the new reality, which requires us in some cases to act as police officers with respect to our clients. So it is no longer a case of, and I'm so sure that Senator Alaha will bear me out on this. Yes, there's such a thing called client-attorney confidentiality, but that principle, established over hundreds of years, is no longer absolute. The banks are asking for more and more information. Before I left private practice, I was being asked to provide invoices from clients. So the banks now want to know who my clients are. That is quite a stretch for me. I have attempted to, without success, to rally the Law Association when I was in practice, but this is the new reality. And it is not only lawyers, it is journalists are not affected as yet. So you can sit down and relax for a bit longer. But we've been affected, and of course, financial institutions have been, the banks and financial institutions have been terribly affected. Those principles which govern banking confidentiality, they've all been but destroyed. So again, that is a cost of doing business in the new reality. Now, Senator Arawi. Now, with respect to the recommendation that this go to a select committee, I have to say that the bill is not going to go to a select committee, and it's not going to go for this reason. Well, for a number of reasons. One, the deadlines do not permit it. Two, no FATF bill, none, whether you've been in charge of dealing with it, whether I have done it, whether former Attorney General Ramesh Lawrence Maharaj has done it, has gone to a select committee or a joint select committee. We've all been under the same type of pressure. Now, that's not to say that we cannot break with tradition. It's just to say that I want to know what makes what we are doing this evening so different to what we've done before in terms of time. And you have made some points. Now, I say that, and before you spring up and you say, well, the Global Forum bill went, you know that, as I do, that has nothing, that's not an FATF piece of legislation. It is tax, and there's something else, factor, not FATF, tax as well. Both went to joint select committees or select committees. No FATF bill has gone. Now, the points you've made with respect on, well, in my note, I put it as this: is the law perfect? And of course, no law is perfect. Otherwise, we would not be amending law. We won't be amending the law this afternoon. There'll be no need for any amendment to legislation. But the real point, you're pointing out some problems, some of them which I agree with in technical terms, as was Senator Choate, who I have not got, well, she spoke after you. But there are a couple answers. The laws are always speaking, and if we discover that something is unworkable, this is the Parliament. Our job is to fix things which are unworkable. And if I could just remind you, and I'm not throwing stones here, but some of these pieces of legislation, I hope that's not Senator Cummins who said yes. You know, I'm trying my best this evening to behave. You all fellas, you guys know that I am a well-behaved person generally, right? Better keep quiet. Okay, so there have been sometimes 17, okay. In one case, there were 4 amendments in 2018 to the Proceeds of Crime Act, with which Senator Choate spoke about. 4 amendments in the space of 1 year. I saw something looking like 11 amendments in the case of, I have 5 to the Securities and Industries Act, 4 in 2018, 2 in 2021, 2 in 2020. So the legislation is, we amend the law when there are serious problems, if we have timelines to meet. That has always been our practice. We are not oblivious to the fact that this is a democracy and that ultimately we answer to people. And that if people are affected, real people are affected, then we have to fix the law. So in respect of the typographical errors, those could be what we call typographical errors. Those could be dealt with, as you know, by the Law Review Commission. In respect of the errors of substance, if they require further legislative action, I commit to further legislative action, keeping our deadlines, bearing in mind the fact that the minister in the Ministry of the Attorney General is traveling to Panama on Sunday or Monday to attend a CFATF meeting in Panama, at which he will have to report on this legislation. Now, with respect to the other laws, the controlled operations that you spoke about, you would not know, but the TTPS has asked us to hold on that. Okay, there are some issues. It's a national security issue. There are some issues on it. They've asked us to stop work on that, and we have. So we are continuing to work with them. We understand what the problems are, and as soon as practicable, the Senate will be hearing from us on it. Now, with respect to Senator Choate, yes, those rules of court problems. I remember, and I was talking about the Gypsy and Chaitan case, which is how old? 26 years old, when that, I see the President of the Senate smiling. It's a decision of Justice De La Vassille. We had no rules to govern election petitions at that time. I was a very, very young junior counsel in it. And basically what De La Vassille had to do is to make up, say, well, okay, I'm looking at the High Court rules and this is what I am doing. And this, it's also the case in the Gilal case, which you said was one of my, that is my case. I think that was one of the last cases I did before I came in to this house. It's still a waiting decision, but I'd like to see what the court does on it. So that is a problem. It is an unfortunate problem. I took a note on it, and I took a note on the point that there is a need for us to develop a working, some sort of working group to oversee this legislation. Of course, you know that I don't practice on the criminal side, so that my experience will be on the civil side. But we have problems on the civil side as well. I am going to commit again to this house this evening to do something about the rules in the legislation and about setting up a committee, an oversight committee to deal with the problems as they arise. And I think that is it. I enjoyed the contribution of Senator John Bates. I do not agree that we can have the sort of widespread consultation that you are speaking about in respect of this type of legislation. The NAMLAC is established to do exactly that in respect of stakeholders, but by the time it gets to us, that is seldom possible. So, Mr. Speaker, Mr. President, I'm back and forth. Mr. President, with those few words, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to amend the Trustees' Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force, be now read a second time. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it.
Act to amend the Trustees Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1201, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnerships Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force.
Honourable Senators. The Honourable Attorney General.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the Miscellaneous Provisions FATF Compliance Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senator, the question is that the Miscellaneous Provisions FATF Compliance Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate will now go into committee of the whole to consider the bill clause by clause. Advise me when you are ready.
Yes, Chair.
Yes. Honourable Senators, there are no amendments before this Honourable House. As such, with your leave, I am proposing we take all the clauses collectively. Senator Alvaro.
Thank you, Mr. President, for the recommendation. I have a few questions that I'd like to ask for elucidation on the record, but ought not to detain us too long in respect of a few of the clauses. So if actually there are only 13 clauses, could we perhaps take them one by one? 1 and 2 obviously are not a problem, just jumping straight to clause 3.
You have questions on all the clauses?
On a few of them, Mr. President.
Would you like to identify them?
On clause 3,
3,
clause 5,
5,
clause 7, clause 8, clause 9,
9,
and clause 10.
and close. All right, so we'll take the first two.
Clauses 1 to 2.
The question is that clauses 1 to 2 stand part of the bill. The question is that clauses 1 and 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 and 2 now stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. Senator Alwari.
Thank you, Mr. President. Mr. President, if I may, through you, just ask the Attorney General for an understanding with respect to clause 3B. This is on the first page of the bill. In Roman 1, where we delete subsections 1 and 2. The new 1 proposes that we declare the nullity and void and invalidity, voidness and invalidity up front, as opposed to after the Registrar General's refusal under the old or existing 2A. The question I have is, why are we declaring the nullity up front? And if we are doing that, how do we treat with the situation of implied and constructive trusts?
Okay. So we've deleted 1 and 2. 1 is spent already. I think the time for registration expired in when?
Yeah, 6 months has passed. Yeah.
14th of April 2025. So it's been replaced by 2 clauses, both of which declare that the clause will be null and void. Right. If it still exists, unless the
It's registered.
unless it is registered. So that's it.
Thank you, AG. What I'm driving at, and perhaps you can assist me here, is so unless something is registered within this particular time frame, unless something is registered, unless a trust which is registrable, either an express trust or a legal arrangement, unless it is registered within subsection 1 and subsection 2 within those time frames, it's null and void. My problem with this, which I'm trying to wrap my mind around, is how do we treat with a constructive trust which is determined by a court ex post facto after the time frame? It was never registered. So let's say you go to court and the court determines there was a constructive trust or an implied trust in existence in the case of litigation as at X date, because it's going to state it is retroactive, but it is not registered. The court is therefore denied the opportunity to uphold the validity or even declare the trust, because in law we've said it's void ab initio. It's different from what existed before, where we would go through a process of registration without a declaration of nullity up front.
So the section, Senator Rawi, speaks to express trust, not
Oh.
constructive trust.
But the definition of trust in the ordinance specifically captures implied and constructive trusts.
Perhaps, but that is not what this section is about. This section is about express trust. It doesn't say trust and leave the expression to be interpreted in accordance with general provisions. It says express trust. And that express you, I don't want to use the Latin.
Got you.
But if it's expressed, then.
So AG, I don't propose to, I know we're not going to debate. I'm just putting it on the record for a mark point, because I'd like you to consider it. You gave an undertaking, per se, to have a look at things as the law is continuously speaking. So I've raised it in the context of marking what my concern is for inspection, because this is something that I genuinely was in a loop of trying to understand the constructive and implied trust positions because of the reference to the words or other legal arrangement. And that is the conundrum that I was in trying to make sense of what it means. I know what the FATF methodology of a legal arrangement means, but it's not expressed in our law. So I'm just putting it on the spot, and I don't suppose that we could solve it now.
Okay.
The question is that
So
clause-
sorry, so Mr. Chair, that was the first one.
No,
If-
is that not?
So clause 3 has several aspects to it, Mr. Chairman. I referred to clause 3, paragraph B, and I dealt with that.
Senator Alvaro, I'm a Democratic chairman, but I want us to follow the rules.
Which are,
There are no amendments before this Honourable Senate. And to detain the Senate in terms of a conversation between you and the Attorney General, I think it is a bit unfair to the Senate.
Mr. Chairman, could I have your guidance on this? In my small 15 years here, I have constantly seen and witnessed questions of the type that I am asking. Because committee stage allows discussion not only on an amendment, but on a clause that is put. This clause is being put, and I have a question.
No. I understand the point you're
Thank you.
making. I am giving some elasticity, but we cannot go on forever. And as I'm saying also, you're correct to some extent, but expressly speaking, you must put amendments to the floor so that all members of the Senate can in fact be privy to your thinking. But when you alone is putting forward concerns, you put the whole Senate at a disadvantage, and the conversation is between you and the Attorney General. So all I'm saying is that while I'm prepared to give you some elasticity, I'll have to get in, and when I find it's going too long, and rule accordingly. So I'll give you the opportunity to intervene again and seek your clarification. Continue, Senator Alvaro.
Thank you very much, Mr. Chairman. Just to confirm, this is just on page 3, at the bottom of page 3. The definition in this section, competent authorities, has the meaning assigned to it by 57A1B. Just a flag, perhaps this is something to be picked up in revision. Just to confirm that that is in fact the correct cross-reference. Nothing more than that, AG. Mr. Chairman, I have no other questions on clause 3.
Thank you, Senator Alvaro. Honourable Senators, the question is that clause 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3 now stands part of the bill.
Clause 4.
The question is that clause 4 now stand part of the bill. The question is that clause 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill. Senator Alwari?
Forgive me, Chair, I have no questions on 5. It's clause 6 that I have the question
Okay.
on. Thank you.
The question is that clause 5 stand part of the bill. The question is that clause 5 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 5 now stands part of the bill.
Clause 6.
The question is that clause 6 stand part of the bill. Senator Alwari?
Thank you, Mr. Chairman. If I could refer you to page 12 of the amendments proposed in clause 6 to poker, and 12 specifically in subsection in B, in section 3, the amendments proposed. In light of the Administration of Justice Preliminary Inquiries Act at JIPA, I'm just asking for a second look at the process flow between Magistrates Court, High Court, particularly when the matters are consolidated. So therefore, it may be a High Court judge dealing with a summary matter and not a magisterial district court judge, as a matter of fact. So I didn't know if that needed some further attention. I'm flagging that for consideration, perhaps at a later date, as a concern.
Honourable Attorney General?
We're open to looking at it at a later date,
Okay.
Chairman.
Honourable Senators?
And Mr. Chair, just to confirm, there are just a few, I think there's one other, which is at page 17 and page 18. There are two other comments or questions. So at page 17, do I have your permission, Mr. Chairman?
Yes.
At page 17, Mr. Chairman.
Yes, continue.
Well, I had asked this in debate. I don't think it's necessary to put it again. I had a question on the new section 45A, so I'll just move as to that retrospectivity concern. The one that I'm looking at is at page 18, and I'm wondering if subsection 3 is missing a choiseul, or is it that it is an indent that is in the wrong place? Comma.
It's just a comma.
In subsection
After
C.
B, after but, sorry.
So that'll take care of in writing. Okay, thank you. And then at page 18, the last one, T as in tango, inserting after section 50, this is the undercover operations. No punishment may be imposed on officials competent. Insofar as we had an LC largely compliant for this, not fully compliant, I believe. My question is this controlled operation in its very tiny form right here? My own view is that it really ought to be a standalone law because it's missing the immunities and conditionalities of the judiciary's warranting process. So I'm flagging that, in fact, if I were to say it this way, if these clauses on undercover were not in the bill, I would probably be saying yes to the bill now. My fear on the inclusion of these clauses on the undercover without a judicial warranting process, I'm honestly very fearful of how it's going to be operated. So I'm not sure if these are required for FATF's compliance, because I didn't see it in the interpretive notes or positions. I like what they want to do. My own view is much like the economic sanctions was taken over by proliferation financing, that it should be in a standalone bill. But for this, and Mr. Chairman, perhaps I could anticipate now, it would be the same comment I'd make in respect of where else undercover operations occurs in the proposed amendments. This one in particular is the one that I'm very concerned about. So I'm not sure if there's room to excise it and come in a full bill or if it's required, but without going into any debate, just to mark the spot, AG, to have a look at it. I would love to support it, but this is sort of a poison pill.
It actually is in the FATF recommendations, and and it can't come out, but I take your point about a separate standalone piece of legislation that's required. It's just run into some difficulties.
Then, Mr. Chairman, insofar
It
as
has
that...
to stay.
Thank you, Eugene. Insofar as that would cut and paste into some of my other concerns, the only other concern I had for the record here would be on the Income Tax Act. So at least for me, for my part, I would just say I'd repeat those concerns for wherever else they appeared in other clauses, but not necessary to necessarily traverse them insofar as I've said them now with your permission. So if you wish, and subject to others not having any questions, those would be my submissions until we get to, I believe, Clause 10, which is the Income Tax Act.
Okay, thank you. The question is that Clause 6 stand part of the bill. The question is that Clause 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 6 now stands part of the bill.
Clauses 7 to 9.
The question is that clauses 7 to 9 stand part of the bill. The question is clauses 7 to 9 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 7 to 9 now stand part of the bill.
Clause 10.
The question is that clause 10 stand part of the bill. Senator Alwari.
Thank you, Mr. Chairman. Mr. Chairman, my reading of the Income Tax Act, Section 97, is that there already exists investigative powers set out in Section 97 to compel, etc. My question on Section 97A is the need for an express statement that the board shall have the authority to investigate any offences. Is this being done because there was a flag as to caution as not having an express power? It wasn't brought to my attention before. Perhaps it was in the new June regulations or guidance notes produced. But is this really required? And if so, why?
Okay, so the board undoubtedly has investigative powers,
Correct.
but the powers are amplified and made clear in sub A, sub B, and sub C. There are powers to take and record statements from persons, including but not limited to taxpayers and so on and so forth, and those are required.
For the record, I support the board having power, but I had not come across the need for it. So you're saying that this was a spotted lacuna which we were asked to address?
Well, the language in the FATF is the widest range of investigative powers.
Thank
This
you.
is what other territories have done.
Thank you.
Any further questions, Mr.
No, sir.
Alwari?
No more on the bill.
Okay. Honourable Senators, the question is that clause 10 stand part of the bill. The question is that clause 10 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 10 now stands part of the bill.
Clauses 11 to 15.
The question is that clauses 11 to 15 stand part of the bill. The question is that clauses 11 to 15 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 11 to 15 now stand part of the bill. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. The Honourable Attorney General.
Mr. President, I wish to report that the miscellaneous provisions FATF Compliance Bill 2025 was considered in committee of the whole and approved without amendment. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that the Senate agree with the committee's report on the miscellaneous provisions FATF Compliance Bill 2025. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Honourable Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Amend the Trustees' Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force, be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Trustees' Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force, be now read a third time and pass. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Division, Mr.
Division
President.
is called.
Mr. Allaha,
Yes.
Mr. Jeremie SC,
Yes.
Dr. Swarat Singh,
Yes.
Mr. Maharaj,
Yes.
Mr. Batiste,
Yes.
Mr. Alexander,
Yes.
Mr. Ratiram,
Yes.
Professor Prasad,
Yes.
Dr. Chaitan Maharaj,
Yes.
Mr. Baig,
Yes.
Mr. Zakur,
Yes.
Mr. Naked,
Yes.
Mr. Jack,
Yes.
Mr. Rashid,
Yes.
Archbishop Graybook,
Yes.
Dr. Brown, Mr. Alrawi SC,
Abstain.
Mrs. Roberts Rajman,
Abstain.
Mr. Dan Paul,
Abstain.
Mr. Cummings,
Abstain.
Mrs. John Bates,
Abstain.
Ms. Choate SC,
Yes.
Dr. Atz,
Yes.
Mr. De La Bastide SC,
Abstain.
Ms. Joan Simmons,
Yes.
Mr. Lewis,
Yes.
Mrs. Lalit Etienne,
Yes.
Mr. McNish,
Yes.
Mr. Gibbings,
Yes.
Ms. Phillips,
Yes.
Mr. President, the results of the division are as follows. 23 senators voted for, there were no senators voting against, and there were 7 abstentions.
Honourable Senators, the result of the division is as follows. 23 members voted for the bill. There were no opposition to the bill. There were 7 abstentions. The bill is accordingly approved.
A bill entitled An Act to Amend the Trustees Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force.
The Honourable Attorney General.
Thank you, Mr. President. Mr. President, in accordance with Standing Order 48-3, I beg to move that a bill entitled An Act to Provide for Implementation of the Recommendations of the Financial Action Task Force with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act, and for related matters, be now read a second time.
Honourable
beg to-
Senators, the question is that a bill entitled An Act to Provide for Implementation of the Recommendations of the Financial Action Task Force, FATF, with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act, and for related matters, be now read a second time. Those in favor say aye. Those against say no. I think the ayes have it. Clerk.
A bill entitled, An Act to Provide for the Implementation of the Recommendations of the Financial Action Task Force, FATF, with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act, and for related matters.
The Honourable Attorney General.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the Counter-Proliferation Financing Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the Counter-Proliferation Financing Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Ready?
Chair, I'm ready.
There are 14 clauses in this bill. Do you have any area that you'd like to raise in particular, Mr.?
No, sir, we fully support this bill.
Okay. All right, so we will, with your leave, I'll put the question and I'll put the clauses collectively. Okay? Go ahead.
Clauses 1 to 14.
The question is that clauses 1 to 14 stand part of the bill. The question is that clauses 1 to 14 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Clauses 1 to 14 now stand part of the bill. The question is that the bill be now reported to the Senate. Those in favor say aye. Aye. Those against say no. The bill will now be reported to the Senate. The Honourable Attorney General.
Mr. President, I wish to report that the Counter-Proliferation Financing Bill 2025 was considered in Committee of the Whole and approved without amendment. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on the Counter-Proliferation Financing Bill 2025. Those in favor say aye. Those against say no. I think the ayes have it. The Honourable Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Provide for the Implementation of the Recommendations of the Financial Action Task Force with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act, and for related matters, be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Provide for Implementation of Recommendations of the Financial Action Task Force, FATF, with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act, and for related matters, be now read a third time and passed. Those in favor say aye. Those against say no. I think the ayes have it.
Division, Mr. President.
Division.
Mr. Alaha,
Yes.
Mr. Jeremie SC,
Aye.
Dr. Swarat Singh,
Yes.
Mr. Maharaj,
Yes.
Mr. Batiste,
Yes.
Mr. Alexander,
Yes.
Mr. Ratiram,
Yes.
Professor Prasad,
Yes.
Dr. Chaitan Maharaj,
Yes.
Mr. Beg,
Yes.
Mr. Zakur,
Yes.
Mr. Nakib,
Yes.
Mr. Jack,
Yes.
Mr. Rashid,
Yes.
Archbishop Greyberg,
Yes.
Dr. Brown,
Yes.
Mr. Arawi SC,
Aye.
Mrs. Roberts Rajman,
Yes.
Mr. Dan Paul,
Yes.
Mr. Cummings,
Yes.
Mrs. John Bates,
Yes.
Ms. Choate SC,
Yes.
Dr. Atz,
Yes.
Mr. De La Bastide SC,
Yes.
Ms. Jones Simmons,
Yes.
Mr. Lewis,
Yes.
Mrs. Etienne,
Yes.
Mr. McNish,
Yes.
Mr. Gibbings,
Yes.
Ms. Phillips.
Yes.
Mr. President, the results of the division are as follows. 30 members voted for, no members voted against, and there were no abstentions.
Honourable members, the result of the division is as follows. 30 members voted for the bill, no members voted against the bill, and there were no abstentions. The bill is accordingly approved. The Honourable Leader of Government Business.
A bill entitled
Oh, sorry.
An Act to Provide for Implementation of the Recommendations of the Financial Action Task Force, FATF, with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act and for related matters.
My apologies, Lord. Yes, the Honourable Leader of Government Business.
Thank you, Mr. President. Mr. President, I beg to move that the Senate do now adjourn to a date to be fixed.
Honourable Senators, the question is that the Senate do now adjourn to a date to be fixed. All in favour say aye. Any against? The ayes have it. The Senate now stands adjourned to a date to be fixed.